number 2 did not testify, although witnesses were called in his defense. He is within his rights to make the choice. Section 12(7) of the Constitution supports the choice he made. It provides that quote, no person who is tried for a criminal offense shall be compelled to give evidence at the trial. This silence does not relieve the Crown of the honors to prove his guilt beyond reasonable doubt. So in this case, his witnesses provide an answer in his name. His witnesses. And the accused must live with the consequences. Whether negative or positive. The following facts are not in dispute in this proceeding. On the night of 9th May 2014, a white double cab Toyota registration number 6336 M366 arrived at the flats next to the residence of General Kamuti. It stopped briefly and then drove off. Eventually stopping a public road next to the residence. The two accused followed it and shot at it several times with AK-47 rifles. An inspection in local revealed that the vehicle was in a public road road 84 paces away from the residence of the general. The occupants, Sepojane and Disabotang, were injured. Jane suffered injuries and survived. Disabo was fatally shot and died at Makwanyani Military Hospital. Jane suffered injuries on the left arm and left leg. Left arm and left leg. The medical form describes the injuries on Jane having been inflicted with considerable force that threatened his life. These injuries were caused by gunshot. He was hospitalized for 11 days. The post-mortem report describes the cause of disabled's death as multiple gunshot wounds of injury to internal organs. The pathologist observed several bullet wounds on the chest and the buttocks. He found 2 deformed metal pieces on the ventral surface of the liver. On examining the vehicle, the investigating officer, PW2, observed about 40 bullet holes on the exterior. On the exterior, and 59 in its interior. The left black tire, the left back tire had punctured. The investigating officer collected the following objects outside the vehicle. Blood samples, 7 cartridges of 7.62 millimeter, 6 bullet jackets, 3 dead bullets. On examining the corpse of the disabled, the investigating officer observed the following. An open wound on the pelvic area, 3 open wounds on the left breast, 1 open wound below the right breast, 3 open wounds on the right buttock, 2 open wounds on the left of the waist. On the left of the waist. On the morning of 10th May, both accused returned their rifles and ammunition to the armor. Each of them returned 4 magazines with 30 bullets. But the fifth magazines were short of bullets. In that, accused number 1 returned 16 bullets. And accused number 2 returned 20. The explanation for the missing bullets was that they were used in shooting at the vehicle. On 12th May, the AK-47 rifles were handed over to the police. The investigating officer received them from Superintendent Koro. Superintendent Koro. He in turn submitted them for forensic examination. The ballistic report was that the rifles could not be linked with the cartridges collected at the scene and inside the vehicle. The question that arises from the results of the ballistic examination is whether absence of a link between the rifles and the cartridges inexorably leads to a conclusion that should inexorably lead to the conclusion that the accused did not use both rifles and bullets. The answer is in the negative for the following reasons. DW1 just testify that he's the one who issued the rifles with the ammunition. Of 30 bullets per magazine. On the morning of the 10th, both accused returned the rifles and the magazines. But each had his fifth magazine short of some bullets. Both accused filed written reports in which they accounted for the shortfall as they are shooting at the vehicle. This was confirmed by accused number 1 in his evidence. And was not contested by accused number 2 when Jase was in the box. The stubborn fact is that the proper AK-47 rifles were handed over to the police as the weapon. The failure to link the rifles with the cartridges would have been fatal to the Crown case if the rifles were in no way connected to the accused. And the accused had denied using them in the shooting. The defenses that emerged from the evidence are the following. The first defense is of mistake. The second defense is obedience to superior orders. That is the red alert. And the third is justified homicide. No, justifiable defense. In other words, it's justified because they shot, according to them, in an attempt to arrest. The Lesotho Defense Force is treated in terms of Section 146 of the Constitution. Among its duties in Section 5 of the Lesotho Defense Force Act
Section 5
is the maintenance of law and order and prevention of crime. In carrying out this duty, soldiers are bound to respect human rights and not resort to unnecessary use of force. They should indeed. That may lead to loss of life. Section 5 of the Constitution circumscribes the use of force in the following circumstances. Circumscribes. It sets boundaries on the use of force. The first boundary is that the use of force can be employed in defense of a person from violence or defense of property. The second one is in order to give effect to a lawful arrest or to prevent the escape of a person lawfully detained. The third is for the purposes of suppressing a riot, insurrection, or mutiny. To suppress a riot, insurrection, or mutiny, a rebellion. The fourth one is in order to prevent commission of an offense by a person. The last one is force can be used in a lawful act or war. The defense of mistake is provided for in Section 13 of the Penal Code. It reads, and I quote, a person who does or omits to do an act under an honestly held but mistaken belief in the existence of a state of affairs is not responsible for the act or omission to any greater extent of the real affairs, of the real state of affairs had been or shall believe them to be. Not greater. Section 18 of the Penal Code provides for the defense of superior orders in this way. Subsection 1 reads, a person who is placed in authority. Subsection 1.
Subsection 1.
Over another person commits an offense if he or she issues orders that are clearly or manifestly illegal. The second requirement is that it shall not be a defense to a criminal charge. That the offense specified in the charge that was carried by the accused person was acting under clearly or manifestly legal orders of a superior placed in authority. Yes, it is not a defense. Section 51 of the Lesotho Defense Force Act provides as follows.
Section 51,
One, any person to this act who in such manner as to show defiance of authority disobeys any lawful command, disobeys or sent to him personally, commits an offense. Any person subject to this act who, whether willfully or through neglect, disobeys any lawful command, committed an offense. Section 42(1) of the Criminal Procedure and Evidence Act provides that.
Section 41, CPE,
No, 42(1).
42, my lord.
Yeah. Provides that when any peace officer or private person authorized or required to act under this act to arrest or assist in arresting any person who has committed or is on reasonable grounds suspected to having committed any of the offenses mentioned in part 2 of the first schedule. I don't think we have to interpret that.
Thank you, madam.
Attempts to make the arrest, and the person whose arrest is so attempted flees or resists and cannot be apprehended and prevented from escaping by other means than by the peace officer or private person killing the person so fleeing or resisting, such killing shall be justified with homicide. I'll tell you then, I'm discussing the law, I'll tell you when to interpret the facts.
Thank you, my lord.
Section 5.2 of our Constitution is identical with Article 2.2 of the European Convention of Human Rights 1950. In interpreting the article in Mackay, the European Court of Human Rights said, and I quote, "The text of Article 2, right as a whole, demonstrates that paragraph 2, Article 2.2 does not primarily define instances where it is permitted intentionally to kill an individual, but describes the situations where it is permitted to use force, which may result as an unintended outcome in the deprivation of life. The use of force, however, must be no more than absolutely necessary for the achievement of one of the purposes set out in subparagraphs A, B, or C of that article." Unquote. In this respect, the use of the term absolutely necessary in Article 2 of the European Convention of Human Rights indicates that a stricter test of necessity must be employed from that normally applicable to determining whether state action is necessary in a democratic society. In particular, the force used must be strictly proportionate to the achievement of the aims set out in subparagraphs 2A and B of the said article. In keeping with the importance of this provision in a democratic society, the European Court, in making its assessment, subjects deprivations of life to the most careful scrutiny, particularly where deliberate use of force is used, taking into consideration not only the actions of the agents of the state who actually administer the force, but also the surrounding circumstances, including such matters as the planning and control of the action. In Andrew, the European Court of Human Rights expounded further in Article 2 of the Convention, saying, and I quote, "As the text of Article 2 itself shows, the use of legal force by police officers may be justified in certain circumstances. Nonetheless, Article 2 does not grant carte blanche. Unregulated and arbitrary action by state agents is incompatible with effective respect for human rights. This means that, as well as being authorized under national law, policing operations must be sufficiently regulated by it, within the framework of a system of adequate and effective safeguards against arbitrariness and use of force, and even against avoidable accidents. Agents of the state who actually administer the force, but also all the surrounding circumstances, including such matters as planning and control of the actions under examination." Unquote. Article 2.2 of the European Convention uses the words "quote, use of force which is no more than absolutely necessary." Unquote. Section 5.2 of our Constitution uses the words "use of force to such extent as is necessary in the circumstances." Unquote. The two provisions reference the test of necessity. The slight difference in the wording does not render the jurisprudence of the European Court of Human Rights irrelevant to the meaning of Section 5.2. Therefore, this court adopts this jurisprudence as a true exposition of the permissible limits for use of force in preventing crime or effecting arrest. Section 42.1 of the Criminal Procedure and Evidence Act, which provides for justifiable homicide, was discussed by the Court of Appeal in the case of Goi and others versus Rex, Lesotho Appeal cases 2009 to 2010 350. This is what the court said in paragraph 21 and 22. Quote, "As to the action which the subsection permits the accused to take, the words cannot be apprehended and prevented from escaping by other means than by killing clearly indicate that the killing has to be necessary. What the legislature does not expressly state is whether what is meant by reasonably necessary. In Brace, the court said in its course of reasoning, that if the killing was necessary, it did not matter that it might be unreasonable. However, in matter above, the appellate division, in a majority judgment of 4 judges, in a case dealing with the same provision that was involved in Brits, said that it was clear that the section envisaged that lawfulness only arose where no other force than killing could reasonably be applied to overcome resistance to escape. Here too, so it seems to me, the then South African position, as reflected in that passage, correctly reflects the law of Lesotho in respect of section 42.1. It follows that the killing in the present matter had to be shown to be reasonably necessary. In the appellant's reliance on section 42.1, it is implicit that they accepted that there had been no arrest, but that the relevant appellants were attempting to make an arrest. Nevertheless, the crucial point is that unless the intended arrestee knows that it is sought to arrest him, leaving aside what the cause of the attempted arrest may be, it cannot be said that he resisted or seeks to escape from an attempted arrest within the meaning of section 52.1. Unless he is resisting a lawful attempt to arrest him, no force, much less legal force, can be used to try to stop him from fleeing. Therefore, to bring the attempt and subsequent force within the protection of section 42.1, the intended arrestee must know that an attempt is being made to arrest him. This is particularly so where the intending arrester is in civilian clothing, and even more so where he is known as a civilian to the intended arrestee. The latter would otherwise be entitled to regard resistance or escape as entirely lawful and to act accordingly. Section 13 of the Penal Code references an act done in honest but mistaken belief in the circumstances. The law is that the mistake must be bona fide and not the killing itself, the so-called error in objecto. Professor Snyman explains by positing the following scenario. Quote, what is the position if X intended to shoot Z, but it subsequently transpires that he mistook his victim's identity and in fact shot Y? Here his mistake did not relate to whether it was a human being he was killing, but to the identity of the human being. Murder is committed any time a person unlawfully and unintentionally kills a human being, and not merely if a person kills another particular human being who, according to his conception of X, corresponds to the person he wanted to be the victim. For this reason, X in this case is guilty of murder. His mistake about the object of this act will not exclude his intention, because the mistake did not relate to an element contained in the definition of the crime. In Pistorius, the accused fatally shot his girlfriend, who was in a toilet, believing that she was an intruder. He was unaware that the girlfriend had gone to the toilet. The court found him guilty of culpable homicide. It explained the principle of error in objecto as an quote. On the other hand, error in objecto occurs where A, intending to kill B, shoots and kills C, whom he mistakenly believes to be B. In these circumstances, A is clearly guilty of the murder of C. His intention is directed at a specific predetermined individual, although he is in error as to the exact identity of the individual, irrespective of whether the name of the individual is B or C. There is thus the error, in the case of error in objecto, so to speak, an undirected mens rea, which falls upon the person it was intended to affect. The error as to identity of the individual, therefore, is not relevant to the question of mens rea, unquote. In reversing the verdict of homicide and substituting it with murder dolus eventualis, the Supreme Court of Appeal said, and I quote, this finding goes to the heart of the first question of law reserve, that is, whether the principles of dolus eventualis, including the so-called error in objecto, were properly applied. In this regard, it is necessary to stress that although a perpetrator's intention to kill must relate to the person killed, this does not mean that the perpetrator must know or appreciate the identity of the victim. A person who causes a bomb to explode in a crowded place will probably be ignorant of the identity of his or her victims, but will nevertheless have the intention to kill those who might die in the resultant explosion. Relating to the lexicon of a lawyer, this is known as intent in the form of so-called dolus indeterminatus, that is killing of an indeterminate person. It is not a form of intention apart from dolus directus or dolus eventualis. It is merely a label meaning that the perpetrator's intention is directed at a person or persons of unknown identity. A perpetrator can therefore act with dolus indeterminatus simultaneously with dolus eventualis. For example, as Neyman points out, and as this court has recently observed, our courts have consistently held persons engaged in a wild shootout in the course of an armed robbery to be liable for murder on the basis of their having acted with both dolus eventualis and dolus indeterminatus, where persons were killed as a result. What was in issue, therefore, was not whether the accused had foreseen that River might be in the cubicle when he fired the fatal shots at the toilet door, but whether there was a person behind the door who might possibly be killed by his actions. The accused's incorrect appreciation as to who was in the cubicle is not determinative of whether he had a requisite criminal intent. Consequently, by confining its assessment of dolus eventualis to whether the accused had foreseen that it was River behind the door, the trial court misdirected itself as to the appropriate legal issue. As a matter of common sense, at the time the fatal shots were fired, the possibility of death of the person behind the door was clearly an obvious result. And in firing not one but four, such a result became even more likely. But that is exactly what the accused did. A court blessed with wisdom of hindsight should always be cautious of determining that because an accused ought to have seen a consequence, he or she must have done so. But in the present case, that influence is irresistible. A person is far more likely to foresee the possibility of death occurring where the weapon use is a lethal firearm, as in the present case, than say a pellet gun, unlikely to do serious harm. Indeed, in this court, counsel for the accused, while not conceding that the trial court had erred when it concluded that accused had not subjectively foreseen the possibility of the death of the person in the trial, was unable to actively support that finding. In the light of the nature of the firearm and the ammunition used, and the extremely limited space into which the shots were fired, this difficulty is understandable. In these circumstances, I have no doubt that in firing the fatal shots, the accused must have foreseen, and therefore did foresee, that whoever was behind the toilet door might die, but reconciled himself to that event occurring and gambled with that person's life. This constituted dolus eventualis on his part, and the identity of his victim is irrelevant to his guilt. His counsel argued that it had to be inferred that he must have viewed whoever was in the toilet a danger. But as pointed out in the Oliveira State versus Oliveira, 1993, Volume 2, South African Criminal Reports 59, Appellate Division, the defense of putative private defense implies rational but mistaken thought. Even if the accused believed that there was someone else in the toilet, his expressed fear that such a person was a danger to his life was not the product of any rational thought. The person concerned behind the door, and although the accused stated that he had heard a noise which he thought might be caused by the door being opened, it did not open. Thus, not only did he not know who was behind the door, he did not know whether that person in fact constituted any threat to him. In the circumstances, although he may have been anxious, it is inconceivable that a rational person could have believed that he was entitled to fire at this person with a heavy caliber firearm without taking even that most elementary precaution of firing a warning shot, which the accused said he elected not to fire as he thought the ricochet might harm. This constituted prima facie proof that the accused did not entertain an honest and genuine belief that he was acting lawfully, which was in no way disturbed by his vacillating and untruthful evidence in regard to his state of mind when he fired his weapon. In order to disturb the natural inference that a person intends the probable consequences of his actions, the accused was required to establish at least a factual foundation for his alleged belief of an imminent attack upon him. This the accused did not do. Consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom, and when there was, he did. In doing so, he must have foreseen, and therefore did foresee, that the person he was firing at behind the door might be fatally injured. Yet he opened fire without having a rational or genuine fear that his life was in danger. The defense of putative private or self-defense cannot be sustained and is no bar to a finding that he acted with dolorous eventualities and causing the death of the deceased, unquote. The defense of obedience to superior orders requires that the command to do an act must be lawful and not clearly unlawful. Is it interpreted? And not clearly or manifestly unlawful. That is the command. The command must be lawful and not clearly or manifestly unlawful. This means that commanders must not issue orders that are clearly or manifestly in contravention of the laws of this kingdom. The culture of command and control which is the cornerstone of discipline in the army, yields to the imperatives of the rule of law, is bound to obey the rule of law. The test for manifest unlawfulness is objective. A reasonable man. The order must not be so contrary to the basic ideas of law it should not be contrary to the basic ideas of law and justice. So as to admit no doubt of its understanding. The defense will succeed. The defense of superior orders will succeed if in carrying out the order which is clearly or manifestly unlawful.
mme taba eo e bonalang pepenene gore e ka thoko molao
A soldier does not do more harm than is necessary.
gore lesole ga le etse tshenyo kapo ntho ga le etse tshenyo e fetang eo e ka etsalang tlasa maemo a wa sebetsang tlasa ona.
This is the message of Section 51 of the Lesotho Defence Force Act.
mme ona ke molaetsa wa karolo wa temana ya 51 ya Lesotho Defence Act, Lesotho Defence Force Act.
It criminalizes disobedience of lawful commands.
It
It makes it an offense
etsa tolong molao
to disobey a lawful command,
go ganana le taelo ya molao e fanwang,
not to disobey an unlawful command.
e se go ganana le taelo ya molao e fanweng ke bolaodi ba sona.
Not to disobey an
o
unlawful
e se
command.
o se mamele taelo ya molao e fanweng ke bolaodi ba
No,
sona.
which is unlawful. Let's interpret what I'm saying is that the commanders in the Lesotho Defence Force cannot issue unlawful orders.
Molaodi wa sesole ka gara molaodi wa sona a ke ka fana ka ditaelo tse seng tse ka thoko molao.
And junior soldiers are entitled to disobey unlawful orders issued by commanders.
mme masola ka tlasa hae a lokela gore a se ka dumela ditaelo tse ka thoko molao le ha di fanwa ke bolaodi ba sesole.
Now, Section 51 should be read together with Section 18 of the Penal Code that criminalizes issuance of unlawful orders
mme
and
section
that
51
their obedience.
Section 51 e tlameha e balwe gammogo le Penal Code ya number 18 e hananang kapo e etsang tlola molao go fana ka ditaelo tse seng molaong.
Weaving together the threads of these two sections,
mme ga re kopanya ditlola tsa di-section tsena tsa molao tse pedi,
it becomes crystal clear that the intention of Parliament
wa hlaka gore morero wa parliament
in enacting Section 51 of the LDF Act and Section 8 of the Penal Code
go kenya tshebetsong section 51 ya Lesotho Defence Act le Penal Code ya number 18.
The intention of Parliament is to ensure that the army
Morero wa parliamente o go etsa gore sesole
does not become an institution of lawlessness and criminality.
o sesole e se ka ba setsi kapa institution ya boitaolo fela go sa tsamaisong ka molao
And criminality
mme le lepatlelo la dilo tsa molao
perpetrated under the guise of command and obedience.
mme tseo di etswang di ka tseloko la gore ke go mamela ditaelo tsa ka bagodimo.
The law talks to lawful command and responsibility.
Molao o bua ka ditaelo tse nepagetseng tsa molaong mme le go ka boikarabelo.
Thus,
mme ka bo
the culture of command and control
mme tsamaiso kapa tlwaelo ya tsamaiso le tsamaiso
which are critical for army discipline
mme tse leng bohlokwa bakeng sa ho etsa discipline taba sesole
does not relieve soldiers,
ho ga o bolele gore
does not relieve,
ha entse tshotso dinaleng ho masole
irrespective of their hierarchy in the chain of command.
ho sa tsotle le gore na maemo a bona ho latela taelo ya sesole ho latela hierarchy ya sesole na e jwang
Of criminal responsibility for committing crimes.
gore ditlolo tsa molao mo ditlolo tsa molao di etsahetseng teng go ba ka fana bana molao ka tlola molao mo ditlolo tsa molao di etsahetseng teng.
It is not enough for a soldier
Ha wa lekana fela gore e be lesole
to honestly believe he is doing his duty
gore fela ka nnete e etsa mosebetsi wa lona
when he issues orders to kill non-combatants
mo le fana ka ditelo tsa go bolaya ba sa boneng
and civilians.
le masafilone fela
Such a soldier obeys such orders.
mme lesole leo e be le dumela taelo tse.
A soldier must, in addition,
Lesole le tlameha gore hodima se seng
be certified that the command
gore
and orders are lawful.
le tla ba le kgotsofatsa gore taelo e di fuwang ke taelo e molaong.
This dynamic of military discipline, I don't think you'll have to This dynamic of military discipline and safeguard from criminal responsibility is well articulated in Kagi, which is a decision of the U.S. Court of Military Appeals, said, and I quote, "A determination that an order is illegal does not of itself assign criminal responsibility to the person following the order for acts done in compliance with it. A soldier taught to follow orders and special attention is given to obedience to orders on the battlefield. Military effectiveness depends on obedience to orders. On the other hand, the obedience of a soldier is not the obedience of an automaton. A soldier is a reasoning agent, obliged to respond not as a machine, but as a person. The law takes these factors into account in assessing criminal responsibility for acts done in compliance with illegal orders. The acts of a subordinate done in compliance with an unlawful order given him by his superior are excused and impose no criminal liability upon him, unless the superior's order is one which a man of ordinary sense and understanding would, under the circumstances, know to be unlawful, or if the order in question is actually known to the accused to be unlawful, unquote. The test of whether the order is lawful or unlawful is objective, not subjective. If it would appear to be to a reasonable person rather than a reasonable soldier that the order is unlawful, the soldier ought not to obey it. And if he or she does, the act is unlawful and the soldier is liable to punishment. The bombings that allegedly led to the issuance of a red alert occurred in Maseru and not beyond. The bombings? That led to the issuance of the red alert. Occurred in Maseru, not outside Maseru. However, the red alert covered the whole country. This exposed the whole nation to the mercy of heavily armed soldiers who were to use lethal force on sight of any white 4x4 vehicle on the road at night. This potentially brought the populace into confrontation with the army and is unacceptable. As ably articulated by the Supreme Court of India, the one I have to interpret, in Extrajudicial Execution Victims Association, the court said, quote, "Therefore, merely because a person is carrying arms in a disturbed area, he does not ipso facto become an enemy. There has to be something much more to brand such a person as an enemy. That a person is not a mere lawbreaker but an enemy can be determined only by a thorough inquiry. In cases such as the present, there is a greater duty of care and an equally greater necessity of a thorough inquiry, since we must not forget the alleged enemy in this case is a citizen of our country, entitled to all fundamental rights, including under Article 21 of the Constitution. In this regard, it is worth recalling what the Constitution bench said in Naga People's Movement of Human Rights. Our armed forces are not trained to fight and kill our own countrymen and women. To this, we may add that ordinarily, our armed forces should not be used against our countrymen and women. This court observed in Naga People's Movement, in paragraph 39 of the report, that the primary task of the armed forces of the Union is to defend the country in the event of war, or when it is faced with external aggression. Their training and orientation is to defeat hostile forces. A situation of internal disturbance involving the local population requires a different approach. Involvement of the armed forces in handling such a situation brings them in confrontation with their countrymen. Prolonged or too frequent deployment of armed forces for handling such situations is likely to generate a feeling of alienation among the people against the armed forces, who by their sacrifices in the defense of their country have earned a place in the hearts of the people. It also has an adverse effect on the morale and discipline of the personnel of the armed forces. If members of our armed forces are deployed and employed to kill citizens of our country on the mere allegation or suspicion that they are enemy, not only the rule of law but our democracy will be in grave danger. Killing an enemy in cause is not the only available solution, and that is what the Geneva Conventions and the principles of international humanitarian law tell us. Therefore, even while dealing with an enemy in cause, the rule of law would apply. If there have been excesses beyond the call of duty, those members of the armed forces who have committed the excesses, which do not have a reasonable connection with the performance of the official duty, would be liable to be proceeded against. It is quite clear from the various instructions issued and which are binding on the armed forces that minimum force is to be used even against terrorists, militants, and insurgents. This is very much in tune with international law, even in terms of war, when the Geneva Conventions and the principles of international humanitarian law are applicable. There is absolutely no reason why an equally toned down response cannot be given by our armed forces in terms of internal disturbances, and why no inquiry should be held if the response is alleged to be disproportionate, unquote. Then you can begin to interpret. Accused number 1 testified that he shot the vehicle in obedience to a red alert. He said the manner in which the vehicle arrived at the rented flats and left made him believe that it resembled the one which was described in the red alert. The spot where the vehicle had stopped is within, he said it is within the area of their duty. And he said he shot at its tires to stop it from moving away. The assertion that he shot at the tires is false beyond reasonable doubt for the following reasons. So that it does not move. One, the spot where the vehicle has stopped is in a public road, 85 paces away from general communities, residents and rented flats. The only tire that was shot at is the left rear tire. Number 3, the number of bullets holes on all sides of the vehicle belies the version that its shooters shot to immobilize it. Fourthly, the injuries on disabled were on the front and back of her body. This means that the shooting was deliberately aimed at all parts of her body, including the vulnerable ones. Accused number 1 did not want to say anything. That's the fifth reason. He did not want to say anything when asked about the discrepancy between the number of bullets used and the number of holes. Number of bullets and the number of holes of the vehicle. He could not even explain the nature of danger. The nature of the danger. That the vehicle posed to them where it was parked. Accused number 1 considered under cross-examination that he used lethal force not in defensive action, but in offensive action, which is to destroy, kill, and eliminate. DW5. That is Jasi. Testified that accused number 2 gave an explanation for the shortfall of 10 bullets in the fifth magazine. The explanation was that he used them in the shooting. When under cross-examination, DW5 testified that during a red alert order, the special forces shoot to kill, not to scare. The testimony of Jase directly implicates accused number 2 in the 3 counts. And I repeat, the stubborn fact in Jase's evidence is that the special forces shoot to kill, not to scare. In other words, the special forces use or they operate a policy of shoot to kill. The red alert order directed all soldiers to be on maximum alert. The red alert order directed all soldiers to be on maximum alert. They should be fully armed and be prepared to kill the occupants of a 4x4 vehicle and police officers who would attempt to arrest General Kamu. The communication of the red alert order seems to have been done without gathering intelligence on the registration number of the suspected vehicle. And factoring in the possibility that the use of legal force might result in taking innocent lives. No, it did not. It did not factor in the possibility that the use of legal force might result in taking innocent lives. PW's evidence, that is deemed, and that of BW1 is that General Kamudi put the whole army under a red alert. That required the commanders to communicate down to the junior ranks. Throughout the kingdom. The purpose of the red alert order was to respond to a situation of alleged instability. Caused by two things. The first one were bombings on the residences of Diabile and Compulsoire. The second one was an alleged impending arrest of General Kamudi by the police. DW6 General Lesole, the present commander, testified that the red alert order has to be sanctioned by the Minister of Defense as a head of government. And it is of limited duration to address a pending threat. DW6 said he does not remember a red alert order being issued in 2014 and 2015. 2014 and 2015. Although as a brigadier general, although he was as a brigadier general one of the advisors to General Kamudi. This evidence undercuts. This evidence. It undercuts the legal basis of the red alert order. The red alert order was unwritten and communicated verbally down the chain of the command. It was unwritten and communicated verbally down the chain of command. It did not provide clarity on principles and rules to constrain the use of legal force in a manner that its use would justify or meet the test of necessity. Which test requires that force, the use of force, should be proportionate to the aims of preventing crime and effect the arrest of fleeing suspects. These shortcomings or infirmities gave soldiers carte blanche or a license to shoot to kill. The red alert order is therefore clearly unlawful and should not have been obeyed by the accused. But of more importance is that the bombing of residences is preeminently a criminal act. That ought to have been dealt with by Compol Tswana himself. General Kamudi should have inquired from Compol Tswana what he was doing about it. As the leader of LNPS and a victim. Secondly, if, as alleged, General Kamudi was wanted by the police, he should have voluntarily presented himself in order to avoid an arrest. What General Kamudi could not do is to use soldiers to resist and even kill police if they enforce the law. General Kamudi and the entirety of the command of the defense are not above the law. They operate under the Constitution and the Lesotho Defense Force Act. And like civilians, they are amenable to arrest by the police on reasonable suspicion of involvement in criminality. That is the imperative of the rule of law. As said by the Court of Appeal in the Swisbro matter, and I quote, no government, however powerful be its military arsenal, however awesome is its police power, indeed however popular be its actual or perceived support among the people, at any given point in history, and I repeat that, no government, however powerful be its military arsenal, however awesome its police power, indeed however popular be its actual or perceived support, that is the support of that government, dare be permitted to invade any of fundamental human rights. No, they can invade human rights. Unquote. As the adage goes,
jwale ka ha
as the saying goes,
as the saying goes,
quote,
ya tsotsa
be you ever so high,
hona o ka ba godimo ha kae
the law is above you, unquote.
molao o tswela ka godimo ho wena.
The law is not a respecter of uniform.
Molao e se molao ha o tshabe ha o hlomphe uniform ya motho
Position,
kapo maemo a motho a leng hona
status,
kapo hona o mahetla ha kae
power,
kapo hona o matla ha kae
or might.
kapo hona dipotwana tsa hao di kae.
The Lesotho Defense Force Act 1996
Molao wa Lesotho wa Defence Force wa 1996
does not give soldiers and their commanders
ha o fe sesole masole le balaodi ba sesole
immunity from investigation.
hore o ka wa phenywa.
They are not immunized from investigation. It doesn't prevent them.
Matano a bona no ha e tswe ba ka batlisiswa ha be ho na le tsela le dilo tsa molao
Be arrested
kapo go tshwarwa
and be prosecuted.
kapo go bewa ka pela mafoko.
The red alert order
Taba ya red alert
was a machination of General Government
e ne le taba e dibutsweng ke General ka mo tsheletsana ka wena
to weaponize the special forces
go sebedisa special forces go sebedisa ditlo go sebedisa special force
as
ile sebetsa sa hae
against protection of arrest by the police.
go itshireletsa gore sepolesa se lo mo tshwara.
This is totally out of kilter in the Constitution
Mme ho ke taba ena e hlabana ka kotloloho le molaotheo wa naha
and the role of the army.
mme le mosebetsi wa sesole hape.
It is also subversive of the rule of law.
Mme hape ke taba e hananang le puso ya molao.
It is not the business of soldiers to carry out orders to shield their commander from arrest by the police.
E se mosebetsi wa sesole ho tshireletsa dikomandante tsa bona haeba di lo tshwarwa ke sepolesa.
Thus,
Mme ka hoo
the red alert order was clearly and manifestly unlawful.
red alert e ne le taelo e ne e se molaong ka tsela e pepeneng ka tsela e ke nya e thibele.
And should not have been obeyed by the accused.
Mme ne tlameha hore ebe ha ya mamelwa ke bakgosudi.
Section 51 of the LDF Act
Section 51 ya molao o tsamaisang sesole sa Lesotho
states that their obligation, that is the obligation of the accused,
e re boitlamo ba bakgosuwa
is only to obey lawful order.
ke mo mamela ditaelo fela tse molaong.
Unlawful orders they should not.
Ha ba tlameha ba mamele ditaelo tse seng molaong.
In similar vein,
Ka tsela e tshwanang
soldiers cannot just shoot at any vehicle that fits the description and color of one allegedly involved in bombings.
masolo a ke ka thunya fela koloi eo ba bonang e tshwana le koloi ka mmala eo no thweng gore eo e ne e tshwantsha kapo e tshwantsha le koloi eo thweng e ne e sebetsana le komisara dibogo.
It is immaterial that the occupants of vehicle M633
Ha o tsotelle hona batho ba ne ba laka ka koloi eno ya dinomoro tsa M663
refused to obey the instructions of the accused to switch on or off lights.
hona ba ne ba hana ho mamela ditaelo tsa mmuso tsa hore ba time di-light tsa koloi tse ka ntle ba light tse ka hare fela.
Accused wants evidence that he knew the identity of Jani
Bopaki mammuso wa pele wa hore o na tseba Jani.
His evidence is that he knew Jani
Bopaki ba hore o na tseba Jani
and he knew the identity of the vehicle of Jani,
mme o na tseba hona koloi ya Jani ke koloi e jwang.
but does not explain what made him fail to recognize that vehicle when it arrived and left.
Empa ha re tlhaloso bona o tlile jwang le ha ka ba tseba koloi eno ya Jani nako eo e seng e tjeka e seng e tsamaya.
The vehicle, as I said, was shot at a spot in a public road, not the private property of General Government.
Koloi e ka se ke boletse e thutswe tseleng ya setjhaba empa e se pela kapo jareteng ya molaodi wa sesole sa ntlheng General ka mo.
At that spot,
Mme moo
he did not pose
e ne sa be
It did not pose a present and immediate danger. It did not pose a present and immediate danger. Danger to life, property, or limb. The accused were fully aware that there were human beings in the vehicle. They pumped bullets into the vehicle with the intention to destroy it and kill them. Thus, the accused's mistake as to the identity of the enemy is great. Is irrelevant to their settled intention to kill. Mr. Tabia submitted that the reason for the accused to follow the vehicle while firing only shots. His submission is that the reason he submitted that the reason the accused followed the vehicle while firing shots and eventually peppering it with bullets was to stop the fleeing of the occupants who had arrived hurriedly and left the residence in defiance of soldiers' instructions. There is no evidence that Jani and Disebo knew or were aware that the accused were following the vehicle when it left the red flags. Jani's evidence is that he heard from Disebo that soldiers were around. When she screamed that a soldier stood outside the front passenger door. No sooner had she screamed, the shooting started. Clearly, the shooting was not with the aim of effecting an arrest. The bullet holes from all sides of the vehicle show that the intention was not to arrest but to kill. As DW5 Jani said, the special forces shoot to kill and not to scare. Jani and Disebo were not aware that there was an attempt to put them under arrest and fled. Thus, it cannot be said that they resisted or they were about to take flight from a lawful attempt to arrest. For what offense? But even if it be accepted they attempted to flee, the accused used force that is disproportionate and outside permissible limits. The use of lethal force failed to meet the test of necessity.
failure high because
The test which is laid down in section 52 of section 5.2 of the Constitution right with section 42.1 of the Criminal Procedure and Evidence Act.
Section 41 of the CPL, Criminal Procedure and Evidence Act.
The accused also failed. They failed the Kelly test.
What is Kelly test, Maluta?
That case I referred to of the U.S. military appeals court.
Oh, test
and that test is that a soldier should behave like a human being, not an automaton. It follows that the defenses of superior orders mistaken belief and justifiable homicide have no merit and are rejected. In summary, therefore, the court makes the following findings. One, on 9th May 2014, the two accused fired multiple shots
May 2014,
at the vehicle registration M6336 with AK-47 rifles. When they so shot the vehicle, it was stationary in a public road at a distance of 85 paces from the residence and rented flats of General Kadikamo. At that spot, it did not pose a clear and present danger to any life. It was not a danger to any life, limb and property. Two, at no stage were December and Sepo aware that they were being followed. When they stopped at the public road. Otherwise, Sepo would not have alighted to pass water. Three, the vehicle was shot from the rear, front, and all sides. 40 bullet holes were found on the exterior part of the vehicle. The exterior, on the exterior part. And 59 were found in the interior part. 3 of its tires were intact except the left rear tire. This proves that lethal force was not used with the aim of immobilizing the vehicle but to kill and destroy. 4. The accused shot at the vehicle not because their lives were in danger or in self-defense, but they were intent on destroying the vehicle and killing its occupants.
Empa ba ne motlhong wa go senya koloi le go bolaya ba ka ga koloi eo.
5.
Ya bohlano,
The people inside the vehicle, that is Tshepo and Disebo,
batho ba neng ba le ka ga koloi eo e leng Tshepo and Disebo
suffered injuries
ba le maqeba
and death.
le lefu.
6.
Go tshelela
The lethal force was not used to protect life,
matla a senyeganyega ao a go bolaya a na sa sebediswa go sireletsa bophelo
defend property,
kapo go sireletsa thepa
prevent crime,
kapo go sireletsa tlolo ya molao
nor to effect a lawful arrest.
kapo go etsa tshwaro ke molaong.
It was used to destroy the vehicle
Empa e ne e sebediswa go senya koloi
and kill its occupants
le go bolaya beng ba koloi kapa ba ka ga koloi eo
for disobeying the procedure
bakeng sa fela go gana go mamela tsela ya tshebetso kapa procedure
to switch off the exterior lights
go tima di-light tse ka ntle tsa koloi
and to switch on the interior lights on arrival at General Kamudi's rented flats.
le go lighta di-light tse ka gare le go etsa switch off engine ga ba fitlha sebakeng seo sa bodulo sa Jamadan mo le manane a gae.
In shooting at the vehicle with lethal force or the magnitude revealed,
Go thinya koloi eo ka mokgwa wa o ne o tšhintšweng ka ona ka matlang a sebeditswe go ithudi
and the resulted injuries and death,
le dikotsi tse etsahetseng mono ga mmogo le lefu.
the accused subjectively intended to kill them.
Batlosuwa ka kotlologo ba ne ba le motlhogong wa go bolaya
They succeeded in killing the servant,
mme ba ile ba atleya go bolaya Disebo
but by the grace of God failed to kill Sam.
empa ka mokgwa wa modimo ba se ke wa bolaya Disebo.
Can the accused stand up?
Batlosuwa ba kgathalela go ema
On the totality of the evidence,
ka kakaretso ke bopaki kaofela ka pela kgotla
I find both accused guilty of the crimes of murder,
ke fumana batlosuwa bobedi ba bona ba le molato ka ketso ya polao
with direct intent,
polao ka maikemisetso
and attempted murder and damage to property.
le go leka go bolaya le tshenyo ya thepa.
The verdict is, I enter the following verdict.
mme karolo e ke fanang ka yona ke ena.
Count 1 on murder,
Karolo ya pele ya polao,
accused number 1 is guilty,
moqosi wa pele o molato
second accused is also guilty.
le moqosi wa pele le ena o molato.
Count number 2 of attempted murder,
Koso ya bobedi ya teko wa polao,
first accused is guilty,
moqosi wa pele o molato
second accused is also guilty.
le moqosi wa pele le ena o molato.
Count 3, damage to property,
Koso ya boraro ya tshenyo ya thepa,
first accused is guilty,
moqosi wa pele o molato
the second accused is also guilty.
le moqosi wa bobedi le ena o molato.
The two assessors agree.
Mme ba sebetsi mmogo le ena ba babedi ba dumelana le nna.
This means that by virtue of this conviction, your bail is cancelled
Mme
automatically.
go latela karolo ena ke tla go fana ka yona gona go bolela gore beili ya lona e le kgothalantse le fana ka yona e cancelletswe e phalane.
What's counsel? What's your response, counsel? No, what's your response, counsel?
As a court case, this will thank you, Lord. You accept the verdict of the court.
The next inquiry is extenuation. What do you want to do, Mrs. Sade? You cannot read now, isn't it?
Indeed, my Lord, you cannot
So
do now.
we'll have to postpone this case then for extenuation and sentence.
That's the court basis.
How much time do you require to prepare argument on extenuation and sentence? We are only 29 today.
I'm thinking of that at the back of my mind.
Yeah, you see, that's why I'm asking you. How much time would you want to prepare?
My lord, given it won't be less than a month.
Sorry?
It shouldn't be less than a month, my lord.
No, it can't be more than a month. It can't be.
I'll request 3 weeks, my lord.
Because what you need just to tell me, you have to tell me about the personal circumstances of the accused.
Indeed, my lord.
And then next you have to make a duty is to tell me whether they are, in fact, we start with extenuation. The only issue first is whether they say, because extenuation is very difficult. Because we know what the sentence is if there's no extenuation. So that means you can't take more than 3 weeks. I don't see that happening. Because even 2 weeks is still generous.
I'm looking at the week of the 8th of June.
We are going on recess in 2 weeks' time. And I should have been done with this.
Yes, sir. I don't know, my lord.
Anytime you see time with you. It's just that I want to accommodate counsel. Otherwise, if you anytime you see time.
As a purpose, I think.
Mr. Sabe,
My lord.
you have 2 weeks. You need to make submissions because the court rises for vacation on the 12th.
May I request if that would be suitable to the court Thursday the 11th of June.
You know, my challenge on Thursdays is that that's when the Judicial Service Commission sits. Why don't you pitch it before that Thursday? Unless, of course, you want me to sit on a Friday.
No, not on a Friday.
No, not that I wouldn't sit. I have to sit.
How is Tuesday the 9th, my lord?
It's okay.
There's a labor court matter. I may ask my colleague to spend it.
Yeah, no, criminal matters take precedence over civil matters. So that labor court will have to give way. So the 9th?
The 9th is okay.
This case then is postponed to the 9th to consider sentence.
That's the court.
The court adjourns. Can you explain that to the dialogue? The postponement.
Okay, my lord. Niwena is it la jana hatreka is in your kana I
No, it's still the case.
Oh, it's still the case.
Sentencing.
Ofanaka Kahuro protect or la bobedi la Tuesday 9th June.
Yeah.
Yes, 9th of June.
Yeah.
9th is coming. Yes. 9
2026.
June 2026.
Thank you.
Thank you.
The court adjourns.
For please.